welcome to Educational Forum, produced by the Massachusetts School of Law and seen nationwide. The subject for today's show is The North in the Civil War, an annual conference produced by the Massachusetts School of Law and the Blue and Gray Educational Society. Subjects for this conference range from Abraham Lincoln and free speech to Medal of Honor winners in the West. Guest speakers for this conference include leading experts on the Civil War, as well as on the First Amendment. Our conference opens with a press conference on free speech in wartime. Let's join Dean Lawrence R. Velvel as he introduces the 16th President of the United States.
Ladies and gentlemen, it is surpassingly rare, if it has ever happened at all, for a President of the United States to visit a law school. Yet today we are privileged to have with us the 16th President of the United States, Abraham Lincoln. Ever since I have been able to read, and before that long ago day as well, Abraham Lincoln has been the template of presidents. When a president gets into difficulties, he tries to show that what he is doing is in the mold of Lincoln, is what Lincoln did or would have done. Presidents try, it is said in summarization, to get right with Lincoln. This is interesting, is it not? They do not try to get right with Washington or with Jefferson or Jackson, or T.R., or Wilson, or F.D.R., or Truman, or Eisenhower, or Kennedy. No, they try to get right with Lincoln. Such has been the impact of this poetic president. Lincoln's life and views are, in reality, what your school is all about, for he knew as few did, and he said that the country, and therefore the war to save it, was an effort to, quote, lift artificial weights from all shoulders, to, quote, clear the paths of laudable pursuits for all, and, hear this now, to afford all an unfettered start and a fair chance in the race of life. A fair chance in the race of life. And Lincoln also held that it was not good enough for a person to selfishly tend his own garden while neglecting to do good for his fellow men. Quote, I hold that while man exists, he said, it is his duty to improve not only his own condition, but to assist in ameliorating mankind. To assist in ameliorating mankind. Abraham Lincoln faced difficulties nearly insuperable in attempting to fulfill his vision during the Civil War. To overcome some of them, he had to take steps curbing free speech that he ordinarily would never have dreamed of. The problems he faced in the 1860s and/or the solutions he employed repeated themselves in varied forms in 1917, 1918 during the Great War, in the early 1940s during World War I, in the mid and late 1960s and early 1970s during the Indochina War, and today in the early and mid-2000s during Gulf War II. Abraham Lincoln is here with us today to tell us about the free speech problems he faced in the 1860s and what he did about them, and perhaps to comment a bit about today's problems and solutions. Ladies and gentlemen, the 16th President of the United States, Abraham Lincoln.
We're here to talk specifically about the Van Landingham case and the Merriman case. And I would say all told, the military has arrested about 18,000 civilians during the war, nearly all of whom have regained their freedom within a few days of taking an oath to abstain from further secessionist activities. I resorted to the suspension of the writ of habeas corpus because of the substantial sympathy which exists for secessionists, especially in the border states, where I could not rely on local law enforcement officials, as many of them share secessionist sentiment. Suspending the writ was necessary to keep local order. Local officials, for example, made no effort to control the arson and rioting by Confederate sympathizers in several states during the early weeks of the war. There were few federal criminal laws, and none of them applied in this situation. So I had to act swiftly and decisively to preserve internal order and prevent further losses to the Confederacy. In Baltimore, local mobs, abetted by officials, attacked troops passing through the city to Washington. Acting on my orders, the Army began arresting some of the troublemakers, including one John Merriman, a well-known Baltimore social figure, a member of the state legislature, a colonel in the militia, and an ardent secessionist who was organizing a military unit to fight for the Confederacy. Merriman had immediate access to counsel, who quickly filed for a writ of habeas corpus. Since the local military commander had ignored a similar writ issued by District Judge William Giles in the case of a minor who had enrolled in the Union forces without permission of his parents, Merriman's attorney decided to present the petition directly to Chief Justice Taney, on May 26, 1861, when Taney arrived in Baltimore to sit as a circuit judge. He learned that Merriman had been charged with various acts of treason, and that in light of the current crisis, the President of the United States had suspended habeas corpus in the area. The commander of Fort McHenry, General George Cadwalader, ignored the writ and refused to present the prisoner on the ground that the President had authorized the suspension of the writ. 2 days later, Taney delivered an impassioned plea asserting that the suspension of habeas corpus, while permitted by the Constitution, Article 1, Section 9, belonged within the powers of the Congress, and that the President could not suspend the writ on his own authority or authorize any military officer to do so. Acting as the circuit judge, Taney ruled that only Congress had the right to suspend the writ, but I ignored the ruling. The use of habeas corpus in federal courts had been negligible because there were so few federal crimes for which a person could be arrested. And that basically is the Merriman case. And in the case of Val Landingham, the leading copperhead of the Civil War, and who just may have been my sharpest critic, he was active in politics through most of his life, and he was elected to Congress from Ohio in 56, 58, and 1860. Before he was defeated for the 38th Congress in 1862, he returned to Ohio to seek the Democratic nomination for governor. He charged me with wicked and hazardous experiment of calling the people to arms without counsel and authority of Congress, with violating the Constitution in declaring a blockade of southern ports, with contemptuously setting at defiance the Constitution in suspending the writ of habeas corpus, and with coolly coming before the Congress and pleading that he was only preserving and protecting the Constitution and demanding and expecting the thanks of Congress and the country for my usurpations of power. In his last extended speech in Congress on January 14, 1863, Vallandigham reviewed his lifelong attitude on slavery and espoused the extreme Copperhead doctrine when he said, "Sir, the fundamental idea of the Constitution is the perfect and eternal compatibility of a union of states, part slave and part free. In my deliberate judgment," he said, "a confederacy made up of slaveholding and non-slaveholding states is, in the nature of things, the strongest of all popular governments." On April 13th, 1863, General Burnside, commander of the Department of Ohio, without consulting his superiors, issued General Order Number 38, in which he announced that all persons found within the Union lines committing acts for the benefit of the enemies and of the country would be tried as spies or traitors, and if convicted would suffer death. The order enumerated the various classes of persons falling within its scope and announced that the habits of declaring sympathy for the enemy would not be allowed in the department, and that persons committing such offenses would at once be arrested with a view to being tried or banished from the United States. On May 1st, Vallandigham was arrested and his counsel applied for a writ of habeas corpus, which was denied. This time, unlike Merriman, the court agreed with the suspension, and an application was later made for a writ of certiorari to bring the proceedings of the Military Commission for review before the Supreme Court. This application was denied on the ground that the Supreme Court had no jurisdiction over a military tribunal. Burnside approved the finding and the sentence of the Military Commission and made plans to send Vallandigham to Fort Warren, Boston Harbor, for imprisonment. But these plans, before these plans could be carried out, I commuted the sentence to banishment from the Union.
Following Lincoln's address to the press, he answers a few questions. The first question put to him was, why did you refuse to comply with Chief Justice Taney's order to release John Merriman? Where did you feel your authority lied to suspend the writ of habeas corpus? Is it ever appropriate for a President of the United States to ignore an order of the Supreme Court, particularly one that says that the President is violating the Constitution of the United States?
Congress was not in session when I suspended the writ, and the Constitution provides for defense not only against foreign invaders, but against internal enemies as well. I then took steps necessary to repel the attack and put down the rebellion. The Constitution itself says the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. So in the provision found in Article 1, Section 9, this specifically applies to our case. John Merriman not only exercised his constitutional right to disagree with what the government was doing, but engaged in raising an armed group to attack and destroy the government. Chief Justice Taney vigorously defended the power of Congress alone to suspend the right of habeas corpus. He took this position in part because of Article 1, Section 9, the section describing congressional powers. But he ignored the fact that it was placed there by the Committee on Drafting at the Constitutional Convention in 1787 as a matter of form and not substance. Regarding the question, how could I refuse to comply with Chief Justice Taney in order to release Maryland? Do you mean Chief Justice Taney, who never acknowledged succession, massive disregard for federal law, or military attacks on the United States as a threat to the Constitution? Is that the Chief Justice? Okay. But I'd like to hear from our distinguished guests as well.
Well, since many of the senators are in the habit of carrying around copies of the Constitution in their pockets, I've made this a practice myself. And the power to, in fact, suspend habeas corpus comes right out of the Constitution, as Mr. President commented already. Article 1, Section 9, Paragraph 2 says specifically that the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion and invasion, the public safety may require it. Nowhere in that article does it say that only Congress may suspend habeas corpus. In fact, we have a great and bloody rebellion that has been foisted upon us by the southern states. It is the duty of the President to hold the Union together and to use whatever powers he can to do so. As Commander-in-Chief, under the war powers provided by the Constitution, the President of the United States has the power to suspend the writ of habeas corpus. We have here not a case of free speech in the case of Mr. Merriman. We have here a case of incitement and a case of an act to actually burn bridges in and out of Baltimore in the Capitol. So this goes far beyond repression of free speech.
Can I say something, Mr. President?
Yes, ma'am.
First of all, I'd like to make it clear that although I am here on behalf of my employer, the Chicago Times, I speak for a variety of newspapers who have been critical of your administration's positions with respect to repression of the essential freedoms which are set forth in the First Amendment to the United States Constitution, that is the freedom of speech and the freedom of the press. I speak also on behalf of the Iowa City State Press, the Dubuque Herald, the Albany paper, and a variety of others. Your administration, with all due respect, has set about a course of conduct designed to repress any opposition, whether it be mere speech, mere expression, or, as you characterize, incitement, to your policies and the policies of your presidency and your administration. And the matters that you cited, the two cases The Merriman case and the Vallandigham cases are merely two illustrations of individuals who have been jailed as a result of efforts of your administration, some of which you didn't even know about, Mr. President. And I point you to Mr. Burnside, who is clearly a renegade in Ohio and is running around jailing and incarcerating individuals for violating his order number 38, of which you had no knowledge when it was issued, did not approve of it, and yet have done absolutely nothing to stop him from continuing this unconstitutional activity. And I would like to suggest that it has been now about 67 years since the Supreme Court of the United States proclaimed that they are the final arbiter of what is constitutional in this country, that the right of judicial review was one that is implicit in the Constitution. And in Marbury versus Madison, the court, actually it's less than 67 years, it's less than 65 years, has determined that the Supreme Court of the United States is the final arbiter of what is constitutional and not the executive. And you have laid a very bad precedent for presidents to follow and administrations to follow by overtly refusing to comply with an order of the Supreme Court of the United States.
Well, in closing, I would say, as president, I could hardly be expected to let all the laws go to pieces lest that one be violated. And my constitutional role as Commander-in-Chief places upon me the responsibility to defend the nation against imminent destruction.
And I will respond by reminding Ms. Rudnick, the journalist from the Chicago Times, although after hearing the other paper she represents, I wonder which paper she is in fact loyal to. Reminding Ms. Rudnick that the Constitution provides that it is the executive branch that has to quell rebellions. It is the executive branch that fights wars. I read nothing in this document that suggests that the Supreme Court of the United States is empowered to quell rebellions. I read nothing in this document that suggests that Congress is empowered to quell rebellions. It is up to the executive branch and his use of the military force to do so.
You should understand that the people in Maryland were attempting to block access to Washington, D.C., because Maryland was fundamentally a southern and secessionist state. And in those days, to get to Washington, D.C., you had to go through Baltimore, and you had to change trains, much like North Station to South Station in Boston. You had to change trains in Baltimore in order to take another train to Washington, D.C. And if Maryland fell, and if what I will call the guerrilla war in Maryland succeeded, that's not an appropriate phraseology, but I'll use it, then Washington would have been isolated, would have been taken by the Confederates in all probability, and that in itself would have made Europe, France and England, more prone by far to come in on the Confederate side or to try to force a peace, a negotiated peace under which the country would split in two. And indeed, American Union troops, the first Massachusetts regiment that comes south, had been stoned marching through Baltimore to get from one train station to the other. And so Lincoln felt, when he arrested legislators, he suspended habeas corpus along the route. He felt that what he was doing was essential to save the Union. His emotional attitude was illustrated by the fact that he used to look out the window when Washington was still undefended because there were no Union troops there and say, if I remember correctly, Mr. President,
where are they?
Where are they? Why don't they come?
Why don't they come?
So he was faced with a prospect of defeat greater than any, I think, ever in American history, except conceivably for the first 6 months of 1942. when the axis, the true axis of evil, was on the march throughout Europe and throughout the Southeast Pacific.
We need to take a short break, but when we come back, more of the Lincoln press conference.
Listen to smoke before you give it a try. Only you. Don't play with matches. Don't play with fire. Cause there's nothing very funny about rooftop life. Nothing very nice on a homeless mind. So if a gorgeous force is what you desire, don't play with matches. Don't play with fire. Yeah.
Only you can prevent wildfires.
Fire.
Passing gas can be deadly.
Whoa. Oh, something's funky.
Passing gas releases a plume of toxic vapors.
Oh, honey, not in the car.
Like ammonia and hydrogen cyanide.
Oh.
And lethal poisons that can linger even when windows are open. Kids shouldn't be exposed to secondhand smoke. Don't pass gas, take it outside.
Adopt a child from foster care. Just being there makes all the difference.
Why do I call it a funny bone?
Why can't penguins fly?
Like a sea safety. Can we go to the moon on vacation?
If you think it's tough answering these questions, imagine the ones you'll get if your child is diagnosed with cancer. CureSearch.org can help. It's run by doctors and scientists whose research has led to an overall cure rate of 78%. You're not as alone as you feel.
Welcome back. Let's continue with more press questions for President Abraham Lincoln. You said that Vallandigham was arrested for more than words addressed at public meeting. What was it he said or did that was, in your estimation, more than mere words? He merely opposed an order issued by one of your generals, not even by the Secretary of War without your knowledge or consent, that forbade the expression of sympathy for the enemy. You were said to be embarrassed about Vallandigham's arrest and convictions. Why didn't you do anything about it?
Of course, it could be argued that Vallandigham's words were nothing more than a political speech, a speech that caused no physical injury or robbed anyone's purse, uttered to a civilian audience far away from any battlefield. But that is not exactly true. To the extent that Vallandigham persuaded a father, a brother, or a friend to convince a soldier boy that he is fighting in a bad cause and should desert, he really was damaging the military power of the country and jeopardizing the public safety. Arresting Vallandigham, not for punishment of his opinions, but for the prevention of military harm, should therefore lie squarely within the design of the Constitution in providing a separate legal sphere for a cause of rebellion, for a case of rebellion, excuse me. He was charged with publicly expressing, in violation of General Orders Number 38, sympathy for those in arms against the government of the United States and declaring disloyal sentiments and opinions with the object and purpose of weakening the power of the government in its effort to suppress unlawful rebellion. The Military Commission found Vallandigham guilty as charged, holding that his speech at Mount Vernon, Ohio, could but induce in his hearers a distrust of their own government and sympathy for those in arms against it, and a disposition to resist the laws of the land. His arrest was made because he was laboring with some effect to prevent the raising of troops, to encourage desertions from the army, and to leave the rebellion without an adequate military force to suppress it. He was not arrested because he was damaging the political prospects of this administration, but because he was damaging the Army, upon the existence and vigor of which the life of the nation depends. He was warring upon the military, and this gave the military constitutional jurisdiction to lay hands upon him. If Mr. Vallandigham was not damaging the military power of the country, then his arrest was made on mistake of fact, which I would be glad to correct on reasonably satisfactory evidence. Judge Leavitt denied Vallandigham's petition for a writ of habeas corpus, saying, "Artful men, disguising their latent treason under hollow pretensions of devotion to the Union, had been striving to disseminate their pestilent heresies among the masses of the people." But Attorney Bates, General Bates, what would you like to say about this matter?
It has been said that the President is impinging on the right of free speech protected by the First Amendment to the Constitution. I remind the reporters that the right of free speech is not absolute. People in this country do not have the right to say whatever they want, whenever they want to, if it leads to violation of law or incitement of the mob. Mr. Vallandigham here was encouraging people to, in fact, avoid conscription into the military service. It is not the Union that started this great rebellion that we're now engaged in. It is the federal military that is attempting to suppress it. And Mr. Vallandigham was acting in disregard of our duty to hold this Union together. It has been said that the President has violated the right of free speech. I ask you all to read the newspapers and see to just what extent this right of free speech has been violated. This President is perhaps the most criticized president in the history of the United States in the press. He has allowed ample criticism of himself and his policies. It's one thing to allow criticism, it's another thing to allow aid and comfort to the rebellion.
Let's hear from the loyal opposition.
Mr. Bates, need I remind you that after publication of a series of articles by my employer, the Chicago Times, contrary to and against the policies of this administration, your employer attempted to close my employer. I suggest that is hardly effectuation of the First Amendment. What Mr. Vallandigham did, and I am not here to defend him, I am not his attorney, was nothing more than oppose the war. That is what this country was founded on. That's why we have a First Amendment. If people are not allowed to articulate opposition to the policies of those in charge, we will have no union when your employer accomplishes what he seeks to accomplish.
Abraham Lincoln is probably, was probably the most reviled president in American history. The kindest thing they said about him was that he was a monkey. Vallandigham was the head of the Copperheads. The Copperheads were Democrats who sought an end to the war and who thought that we were engaged in a mass slaughter to no avail and for no purpose. There has never been, and in fact, Robert E. Lee, who is accused sometimes of being merely a tactician and not a strategist, felt that as one major strategy for the Confederacy, they might be able to get the North, because of popular opinion, because of people like Vallandigham, to leave the war. He felt that is one of the reasons he went north to Gettysburg. He felt that again in 1864. Never in the history of the United States, I would say, not even in Vietnam, which I lived through and which was truly terrible. And what is going on today does not hold a candle either to Vietnam or to the Civil War. Lose the war. One might say, although the military people say we never lost a battle in Vietnam, and that's probably true. We never lost a set-piece battle, to which the North Vietnamese respond, so what? You lost the war, didn't you? never in the history of the United States, but for Vietnam, has there ever, not even in 1917, 1918, has there ever been any such possibility as there was during the Civil War that internal opposition might cause the loss of the war? And Mr. President, correct me if I'm wrong, but I believe you said in regard to Vallandigham, and if not in regard to Vallandigham, then in regard to another Copperhead, referring to the fact that soldiers who deserted or went AWOL were shot. Must I shoot the poor soldier boy? And you understand that these were young men of 16, 17, and 18. The average age of the Union Army in that war was about 21. Must I shoot the poor soldier boy while not touching a hair of the head of the wily agitator who induces his desertion?
Do you believe the Constitution is different in times of war than in times of peace?
Yes. And let me say that I pointed this out in a letter to Erastus Corning, who was part of a state legislature from the state of New York. And at that time I wrote, "The writ of habeas corpus is indeed the great means through which the guarantees of personal liberty are conserved, but the writ is intended by the Constitution only to operate in times of peace. The Constitution made a separate provision for times of rebellion or invasion, and in those times a different rule has to prevail, which includes certain military arrests and proceedings following from them. This situation is precisely our present case, a case of rebellion wherein the public safety does require the suspension of the writ of habeas corpus." But that's a brief comment, and I'd like my Attorney General to elaborate.
Thank you, Mr. President. The Constitution must be read in perspective. The Constitution has never been intended to be an absolute document. Certainly, one wouldn't argue that a child, a minor, has full constitutional rights under the Constitution of the United States. Certainly, one wouldn't argue that a prisoner, someone who is incarcerated in jail for breaking our laws, is entitled to the full panoply of constitutional rights. Certainly, one wouldn't argue that a non-citizen enjoys the same freedoms and privileges and immunities as a citizen of these great United States. So obviously, the Constitution is meant to be flexible. Times of war call for flexibility. Thank you.
I'd just like to elaborate for the audience on your communication with Erastus Corning, who is a very prominent member of the New York legislature residing in Albany. The people of the state of New York, individuals clearly in the Union, those who have been among your most ardent supporters both politically and militarily, were forced by your extreme conduct in violating the civil rights and liberties of lay persons, not even military individuals, but lay persons, persons not in the military, passed what is known as the Albany Resolves. They insisted, these Albany Resolves insisted that you honor the liberties of citizens, assailed the military's arbitrary arrests and the use of military commissions to try civilians, which, as I remind you, Mr. President, was declared unconstitutional in the Merriman case, a decision which you again decided to ignore by trying Mr. Vallandigham in a military court. And Mr. Corning sent these to you asking for your earnest consideration, and your response was, as you've said, that the Constitution is different in times of war than it is in times of peace. The Constitution says no such thing. And in fact, many individuals believe that it is during times of war where the Constitution has to be most scrupulously honored, because if the Constitution and the civil rights and liberties which are afforded each individual are not honored during times of war, then it will make no difference during times of peace.
The problem that Lincoln faced in this regard arose again in 1917 and 1918 because there were many German-American citizens of this country, and that this went on, and many Russian socialists had come to the nation, and Irish Americans didn't care for England, and there was great fear that the people, by speaking against the war, would turn the population against it. That was preposterous, and is considered historically preposterous. The problem arose again with the Japanese exclusion case in 1941 and 1942, a case you know of, now regarded as an historical botchery for which the country has apologized. And I believe the justice who wrote the opinion and other justices who joined the opinion have de facto apologized. We went through this again in the Cold War in the 1950s. We went through it again in the time of Vietnam in the 1960s. We have gone through it again in the last few years. And with the I would say that with the sole exception of Lincoln's time, never have people, and some would say today, never have people who have been repressed, suppressed, really offered any kind of serious threat to the country's effort in wartime. I think that history most likely, this is just a historical prediction, I think history most likely is going to say that we went way overboard again in the early part of the 2000s, but that remains for history to say. I simply point out to you that except for Lincoln's day, and excluding the times of the Revolution and 1812, which are also involved in this calculus, but except for Lincoln's day, with those exclusions, there never has been a time really when the United States was seriously threatened by dissent, although it is invariable, in two words, as they say, invariable, that we go nuts in times of war and begin repression and suppression.
Can I just respond to the Dean's comment? You omitted another time during the history of this country where extremism overtook common sense, and that is during the late 1700s during the Alien and Sedition Acts. And I need not remind the President that the Alien and Sedition Acts were so repressive that Mr. Jefferson, before he became the President, then representative from Virginia, suggested that the Virginia legislature pass a law stating that they would not comply with the Alien and Sedition Acts because they were so unconstitutional they could not possibly be effective, and therefore the state did not have to comply with them, notwithstanding the existence of the Supremacy Clause in the Constitution. Now, Virginia did not do that, but there was nothing more in the Alien and Sedition Acts than the same prohibitions that existed in Mr. Burnside's Orders Number 38 and other policies of this administration. That is your administration, Mr. President.
Well, may I remind the lady from the Chicago Times that President Lincoln has in fact not asked for any law passed anything like the Alien and Sedition Acts, that he has in fact permitted a free press to continue, which is one of the reasons why you're here today, madam, a free press to continue. He has endured criticism from even within his own party as well as from the Democratic side. So we're not even close to the Alien and Sedition Acts.
And when Mr. Burnside, his representative in Ohio, attempted to close down the offices of the Chicago Times because he did not like what my publisher, Mr. Story, was writing, that was also an effort to further the free press protected by the First Amendment. Does he not take responsibility for that which his minion, Mr. Burnside, is doing in the state of Ohio?
The Chicago Times is up and running now, madam. I predict great things for the Chicago Times. I think it will survive well into the future. And I'll point out again.
No thanks to you, sir.
I'll point out again that there's a difference between incitement and free speech and the free press.
From its inception, the Republican Party has been devoted to free speech. How can you, as head of that party, allow persons who have done nothing more than have viewpoints opposing war be jailed? How can you call for repression of newspapers expressing viewpoints contrary to those of your administration?
I feel like a broken record here, a little too early for a broken record.
Broken gramophone.
I feel like I'm repeating myself again. The press has been and continues to remain free. Ms. Rudnick from the Chicago Times mentioned probably a half a dozen other newspapers that she is here representing today. To the extent that the president has taken any action to suppress this rebellion, most of it has been temporary and measured to only meet the threat that was present. All of these newspapers continue to exist. The press, as I see it, remains free and strong in this country.
I don't need to repeat myself. I think I've made the position of the press, particularly the Democratic press in this country, perfectly clear. And I also should remind the audience and the president that after the Albany resolves were passed, and upon some reflection, he said, "I certainly do not know that Mr. Vallandigham has specifically and by direct language advised against enlistments and in favor of desertion and resistance to drafting." So therefore, everything that he has said here today, based on the contrary, should be taken with a grain of salt.
That concludes President Lincoln's press conference. When we come back, we'll take a look at some highlights from the two-day conference held here at the Massachusetts School of Law. So stay with us.
Hey, yo, Tim, get on your job, kid. We got school, yo. I see you in the window, man. You want me to do? I got the bus here, man. I got connections. We holding up traffic. Let's go. I'm not letting you waste your life like that, yeah.
Can I ask a few questions about the apartment on Park Street?
What was your name?
My name is Juan Hernandez.
It's been rented.
Hello, my name is Sanjay Kumar. I am calling about the apartment on Park Street.
It just rented.
My name is Tyrone Washington. I'm calling about the apartment for rent on Park Street.
It's not available.
I use a wheelchair and...
It's gone.
Hello, my name is Graham Wellington. I'm calling about the apartment for rent on Park Street. Is that still available?
Yes, it is.
Oh, it is?
Housing discrimination is illegal. If you think you've been a victim, call us.
Mrs. Johnson, good to see you again. This is Mike. You can trust him. He looks just like you.
I'll be sucking up to you in order to make you sign the loan.
So, here are your low monthly payments and interest rate as we promised. Here's where they triple. The rest of this is really just here so that we get your house when you can't pay us back.
Such a lovely house.
Predatory lenders are never this easy to spot. Call us and protect yourself with the facts.
2 words for you. Pop quiz. Ready? Name any funny movie. A drama. Name a mystery. And one more thing. Name the movie your kids saw today in science class.
Know what really matters. Know about your kid's school. And know about your kid. Find out 100 ways to know more, do more.
Welcome back. Let's take a look at some highlights from the conference entitled The North in the Civil War. A conference which is unique because it concentrates not on the South's lost cause, but on the reasons why the North had to win the Civil War. Let's take a look at some of these highlights.
There was a sack of Lawrence, which was an outrage. There was the attack on Sumner, which was a further outrage. And one Kansas settler, a New England settler named John Brown, who lived down in southeastern Kansas and who was on his way to help rescue Lawrence from the mob. En route to Lawrence, Brown learns that Lawrence has been sacked. They may have heard, although it's a little uncertain, about the attack on Charles Sumner. Brown was a radical abolitionist, been an abolitionist all of his life. He had parted company with the abolitionist movement because he had come to the conclusion the mainstream abolitionist movement was nonviolent, but Brown had come to the conclusion that the only way to eradicate slavery was with violence. He'd become a violent abolitionist. So, May of 1856, Brown took some of his sons and his son-in-law and some other young men out into the night along Pottawatomie Creek in southeastern Kansas, and they murdered 5 pro-slavery men. This is the Pottawatomie Massacre. And so these 3 events, what happened at Lawrence, the attack on Sumner, and then the Pottawatomie murders, the Pottawatomie Massacre, set off kind of general violence in the territory. So I think Kansas plays a role in bringing on the Civil War, and one of many ways in which it does it is to highlight this moral issue of slavery. It also radicalizes people north and south. It gave the venue for John Brown to emerge and to widen his scope. It made Northerners and Southerners realize more and more their deep cleavages and helped to extend and widen the rift between Northerners and Southerners over these issues of slavery.
So now we'll pick up Lieutenant William Marlin at the Battle of Bayou Bourbeau. Banks, being a politician, oftentimes, as we know, politicians send other people to do their work. So to get to the what he calls the overland route to Texas through Louisiana up the Red River, he doesn't go himself. He sends another general to do this. And so the general is going up through Louisiana, through the Longfellows, Evangeline area in October, November of 1863. And they're encountering a lot of resistance, and so they decide they're going to turn back. And so there's a rear guard, and it's an infantry unit, a couple artillery units, and they're holding the rear guard. And so at that time now, on November 5th, is where William Marlin is, because he's in Nims Battery and he's back at this rear guard. And so suddenly the rebels, cavalry, so the Union at that point has about 1,700 soldiers. The Confederates have at least 3,000, many of whom are cavalrymen from Texas, these crazy screaming Texas on horses, and they suddenly are coming at them. And then in addition, they send on the right flank of the Union, they send infantry through the trees and surprise them. So now all of a sudden, poor Lieutenant Marlin is manning his guns and he's surrounded on all 3 sides. And most of the infantry is headed across the Bayou Bourbeau, which was the waterway there, and now he's kind of stuck. Actually, it was November 3rd. So he's surrounded, so he decides that he's going to cut his way through the rebel lines. And so he tells his men, he says, take your pistols, and we're surrounded on 3 sides. Our way behind us is covered, which is the bridge, the only bridge to get across this bayou, this small river. And he said, take your pistols, we're going to fight our way, and we're going to get across the bridge. All the infantry's left. And so in the Deeds of Honor, Medal of Honor books, a really wonderful engraving, which is this one here. And it's an engraving of Lieutenant Marlin that says, we dashed through our lines, through their lines. And the other title is, Lieutenant Marlin saves their guns. And so he literally crosses this bridge, firing his pistols.
The 6th Massachusetts was the first armed troops to reach Washington. But their route passed through Baltimore, a hostile city of 200,000. They came from Middlesex County, including Concord and Lexington. Some were direct descendants of the Minutemen. They left Philadelphia at 1 a.m. And the plan was to get into Baltimore early and pass through the city without any trouble. Like most American cities, Baltimore lacked a rational transport system, as Boston still does. There was no Union Station. There was no single railroad depot where all the lines came together. So when the troops got to Camden Station on the north side of Baltimore, locomotive is unhitched, horses are attached to the passenger cars, and the horses pull the passenger cars down Pratt Street, a dozen blocks, to the Washington Depot on the south side of the city. Well, the first 7 companies made it through without incident. But after they got past, a mob formed. The tracks behind them were barricaded. The rails are pulled out of the pavement. And the men of the regimental band and 2 companies from Lowell, a company from Lawrence, and a company from Stoneham were caught. They're trapped. They got off the cars. They tried to march through the city, and they were attacked by a mob with bricks and paving stones and road apples. Shots were fired. 1 soldier fell dead. The troops fired in return and resumed their march. Baltimore's mayor ran and got in front of the column and begged the troops not to fire again. But he soon lost patience with his own constituents. He grabbed one of the soldiers' muskets and killed a rioter, and a city policeman shot another. They finally reached the Washington Depot, but they were missing 130 men. The mob pursued them into the station and continued throwing stones and firing even after they were on the cars for Washington. Soldiers killed at least 1 man in the mob firing from the passenger cars as the train pulled out of the station. The 4 killed were Addison Whitney, Luther Ladd, Charles Taylor of Company D from Lowell, and Sumner Needham, Company I of Lawrence, along with 36 wounded. Months later, Maryland Governor John Finley expressed his sorrow to Andrew, an apology that Governor Andrew accepted. And the Maryland legislature voted $7,000 for the families of the dead and wounded.
Nearly 150 years have passed since the Civil War ended in 1865. Why are we still talking about it?
The United States was founded, unlike any other nation, on an idea. And I think because it was idea, it was contested and continues to be contested. And clearly the Civil War, I'm going to make this real brief here, lies at the heart of that. What will freedom mean during this era?
The Civil War remains important to us because it is the single bloodiest event in our history. Over 600,000 military deaths, perhaps millions when you add civilian deaths, and also because it happened on U.S. soil, which most of our military conflicts have not. So it's a searing, tragic event that happened here.
One of the things that I think it continues to be fascinating for is that there is an added horrific dimension to any country tearing itself apart. And we always think of the enemy as somewhere over a boundary, over a border, not so much our own countrymen. And I think that has a somehow a horrific feeling to it.
I think another reason it's so interesting, it's just a great drama. It's a very powerful story, and we have winners and losers and heroes and rogues. We have brilliant strategic decisions, and we have some very classic blunders. And then I think besides the fact it's on our own land where people can physically get to the battlefields, historical sites, there's a great connection there. And then the other thing is just the personal side of it. There's so many personal connections, and so many people have relatives or have some personal connection, which I think really creates a lot of interest and keeps the longevity to the story.
Grant and Twain, who incidentally had taken his name from the cries of the steamboatmen on the Mississippi, Mark Twain, or 2 fathoms, had first been introduced at a Washington reception in 1866. And although it was some years before they met again, they worked diligently to cement their friendship. When Grant moved to New York, Twain often came to to see him. They spent many afternoons talking of the war, mutual friends, and Twain's writing career. Twain worshipped Grant, and in the words of biographer Justin Kaplan, he was a Grant-intoxicated man. Despite differences in temperament and outlook, they had much in common. During the late summer of 1884, Grant began to experience throat pains. At first he ignored them, believing it to be a minor matter. However, they persisted, and by the time he went to visit his doctor, it was too late. His main anxiety was that his family, and particularly his beloved and devoted wife Julia, should not be burdened by financial hardship after his death. I would like to end with moving words from the personal memoirs of Ulysses S. Grant. I am not egotist enough to suppose that all this significance should be given because I was the object of it. But the war between the states was a very bloody and a very costly war. One side or the other had to yield principles they deemed dearer than life before it could be brought to an end. I commanded the whole of the mighty host engaged on the victorious side. I was, no matter whether deservedly so or not, a representation of that side of the controversy. It is significant and gratifying that Confederates should have joined heartily in this spontaneous move. I hope the good feeling inaugurated may continue to the end. I feel that we are on the eve of a new era, when there is to be a great harmony between the Federal and Confederate. I cannot stay to be a living witness to the correctness of this prophecy, but I feel it within me that it is to be so. The universally kind feeling expressed for me at a time when it was supposed that each day would prove my last seemed to me the beginning of the answer to let us have peace. Thank you.
You know that we're bombarded with math and technology in our everyday lives. We need to remember our past in order to move on with our future. We need to keep history alive. We at the Massachusetts School of Law thank you for joining us. Until next time, be well.